On this episode of Law Weekly, we discuss necessary reforms for the judiciary. We have the views of a senior advocate of Nigeria, Osaro Egobamen. Also showing on the program, highlights from the launch of the Nigerian chapter of the Women in the Legal Profession. We also have details of some of the suggested provisions for the proposed Lagos State Administration of Civil Justice Bill 2022, plus a recap of some of the legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. At a brief ceremony held at the Abuja Council Chambers on Wednesday, the 12th of October, President Muhammadu Buhari swore in Justice Olukayode Ariwoola as the Chief Justice of Nigeria. Justice Ariwoola took the judicial oath of office before the commencement of the weekly Federal Executive Council meeting in the ceremony, which was witnessed by Vice President Professor Yemi Osinbajo, ministers, other justices of the Supreme Court, and the governors of Oyo and Ondo states. Now, my guest, Senior Advocate of Nigeria, Osaro Egobamen, has practiced law for over 30 years. A founding partner of Perchstone and Gray's law firm, he was conferred with the prestigious rank of Senior Advocate of Nigeria in 2008. For a few years now, he's been running 2 42-kilometer marathons to draw awareness to the need for reforms in the justice delivery system. And this issue of reforms is the starting point of our conversation on this episode of Law Weekly.
I think the present Chief Justice of Nigeria sits in a very comfortable position as far as reforms are concerned, because a lot of the work has been done. On the 15th of January, I think, this year, we had a Justice Reforms Summit. And in that summit, we brought together all the stakeholders and all those who are necessary to effect reforms in the administration of justice. So you had the Office of the President, represented by the Vice President, you had the NJC, and then you also had the legislature, represented at the highest level. Representation at the highest level. And there were recommendations made, and I break it down into 3 parts. One is to do with the appointment, selection, appointment, and elevation or promotion of judges. And then the other is to do with budgeting and accounting. And the last one is to do with acceleration of the justice delivery system, accountability and performance of judicial officers. Now, Ajibade headed that particular summit. Tunde Ajibade. And following from there, we decided that that was not going to be a talk shop. So he then transformed it under the former president, Olumide Akpata, transformed it into an implementation committee. The good news is that the present president of the NBA has adopted that particular committee. So what that means is that all what we need to do from all the stakeholders is actually set down in a document. Fortunately for the Chief Justice as well, a research was carried out by the Conrad Arnold Foundation and the UNODC. And they did a field and desk work determining what is required to effect change in the administration of justice. So we have a recommendation that is actually built from all the stakeholders. So you're not going to find anybody objecting to it. So it's a question of council accepting and then hopefully implementing what has been agreed. What we discovered from the research that was conducted is that there was no standard criteria that you needed to satisfy to be elevated to the Superior Court of Records. So what that meant was that we're still relying on the old system. Of course, the National Judicial Policy specifies very clearly that anyone intending to be appointed to the Superior Court of Record must demonstrate exceptional skill, must be meritorious, and finally must demonstrate comportment that is deserving of that very sensitive office. Unfortunately, the mechanics or the mechanism by which we will achieve that objective is not clearly spelled out. So what we've done is to say, okay, let us actually implement what is already in the National Judicial Policy. That will mean creating a criteria which anyone intending to be appointed must satisfy. It might mean written exams. There will be a different system of selection. Selection is different from appointment. Selection relates to the pool from which you appoint. That pool is limited. That's what we've seen. So today, conventionally, is restricted to maybe those in the ministry, those who are sitting judges who will go to the Superior Court of Record. Now, what we've discovered comparative analysis was done in other jurisdictions, that pool is deliberately widened. So you can have somebody appointed from the bar straight to the Supreme Court. You can have a judge who is sitting in the first instance court, elevated, what we call leapfrogging, to the Supreme Court. You expand the pool, and then, of course, gender issues, you broaden the pool. When you do that, then there's a likelihood that you're going to get those who are meritorious. Beyond that, we might also suggest the establishment of a committee that goes out to search for good candidates, who will also then engage the interview process. I tell you, most people are dissatisfied. So today, those who are good judges get there by accident. We have to create a design, a deliberate attempt to ensure that the system produces the best of us.
I've listened to some of the things you've said, and I'm wondering, how do we get the buy-in of the judiciary? Because you've talked about leapfrogging, you've talked about bringing members of the bar onto the bench, and how are we going to get the judiciary to buy into this? Because I've spoken to a number of judicial officers, and what I hear them saying is, oh, we've queued up for so long, we've been waiting to take our turns, why bring in someone else from the outside?
I've heard those arguments, and it's a demonstration of a misunderstanding of what the role of a judicial officer is, with the greatest respect. What we're trying to achieve is not a matter of a personal interest. It's my turn. We're trying to ensure that we restore confidence in the judicial process. What that means is that you get the best hands, and whatever it takes to get those who are skilled, those who demonstrate the comportment, and those who are deserving, then we have to do it. It is not a matter of, it's not a classroom where you simply elevate people by just simply the fact that you were present. You must demonstrate some exceptional skill. The interview process today doesn't do that. So the mere fact that you sat as a magistrate or you sat even as a high court judge may not necessarily mean that you're the best person for the Court of Appeal. It may not even mean that you're the best person to occupy the position of the chief judge of that state. A committee should look at it and get the best hands. And I tell you what, many of the judges who sit today, especially the very good judges, are not happy that a system does not automatically produce the best candidates. Look, you simply need to look at the judgments that are being delivered by the Supreme Court today. And when you compare it to the judgments that were delivered in the 80s and the 70s, I think any honest person will admit that the quality is lowered. Now, why that is so, we can debate that from now till thy kingdom come. But I think the most important thing to recognize is that we have a lowering of standard, we have a lack of confidence in the administration of justice, and whatever needs to be done to restore it, we have to do it. We need to widen the pool from which you select. And I'm talking about widening it not only at the bar, but also at the bench.
So who has the responsibility for driving some of these changes that we've talked about?
That's very interesting. I did tell you that Uluwapata pointed me into the NJC. When he did, he didn't mention it to me, and I said I probably would have, I don't know how I would have reacted because of how we've been so critical about the NJC. But now that I'm there, I think that the responsibility falls on people like me to let counsel understand how we're being perceived. And when I say we, the counsel and then judges, how they're being perceived, and that this confidence, the requisites for the administration of justice is confidence. And to build that confidence, then we have to effect fundamental reforms. So when you say whose responsibility it is, I'd probably take account, I'd probably take some responsibility and say the responsibility falls on all of us, particularly those of us sitting in the National Judicial Council.
You've talked about a national judicial policy that addresses some of these concerns that we've talked about, but I'm wondering, how popular is it among lawyers? Because a lot of people are not aware of it.
I agree with you. I only started to learn more about it because I was appointed into the NJC. Well, no, that's not entirely correct. I've looked at it when we were trying to introduce virtual hearings. So the National Judicial Policy is a fantastic piece of documents. It states very clearly that the process of appointment must be transparent. It must seek to achieve a merit-based system, a skill, and comportments. I think whoever drafted it was thinking in the right direction, right? So the question is, what do we need to do to ensure that we achieve that objective? As a matter of fact, the processes we have today, the mechanics to achieve that seems to undermine the very objective that is clearly stated in the National Judicial Policy. So I think the responsibility of some of us at the council is to simply push to the council the fact that, look, we already have a policy that dictates and prescribes what needs to be done. It is the procedure, the modalities, and the mechanics by which you achieve it that we now need to put in place.
I know there's a committee set up to monitor the performance of judges and even the swiftness of cases in our courts, Trimco or something like that, that was set up, to go from court to court and monitor how cases are being swiftly handled. That committee has been quiet. So is the NJC and even the Ajibade committee looking to rev up that committee so that we can get a lot more information to work with?
Very good question. And in fact, all the reforms that we have done in the past perhaps have been defective in one respect. There hadn't been sufficient collation of information. There's been an information asymmetry. So the former president of the NBA, Oluwapata, set up a committee headed again by Tunde Ajibade. And the concept is to create a reporting system, a live monitoring reporting system. So basically you can tell when a judge sits, you can tell how many files are in his docket, what he does and what he doesn't. And this is live reporting. The NBA is collaborating with the JRP, Justice Reform Project.
Which you're part of.
Yes, I'm a part of that. I'm a proud member of the.
And you all have been so critical of,
Yes.
of this process and how we need to do reforms.
And that's why my appointment into the NJC is fortuitous. I'm very happy about what's happening because we were trying to persuade the NJC to do a lot of things. Now I'm in there. It is a bit complicated. It's not as easy as it looks, but I will do my best. We do have a lot of recommendations coming from the bar and the NJC. But talking about live reporting, the idea is to be able to collate information which will then form the basis of any reforms that we're going to be suggesting. Now, when you have information, it becomes difficult for people to disagree with what you're doing. Unfortunately, I hear that they were almost launching that project, but there's some data protection issues. And once we cross that, maybe even at the NJC, I'm sure that launch will take place almost immediately. And what it will do is performance and evaluation. You'll be able to evaluate the comportment of a judge very easily.
Who will do that?
From what I understand, it will be a combination of the NBA, I think the judiciary is involved and all that. So they will now be monitoring it. You see, normally what happens with appointments or selections is that when a vacancy comes up, then you begin to look for the candidate. That's not how it should be. It's a process that should actually happen so that when the vacancy comes up, maybe at the Supreme Court, you already have a pool. And that pool is a limited pool, absolutely. Now, we did a research, the Justice Research Institute actually held a summit 2 years ago. And Dafferty, who heads the Judicial Committee in the United Kingdom, doing exactly what the NJC does, they went through this process. And they also went through some very difficult moments in trying to change the process. They had a system before where you simply tap people on the shoulder who's going to be a judge. The system worked, for a while, but as things became more complicated and society became more advanced, they needed to introduce a system that would meet the challenges of modern society. What we have lacked here is a permanent system that continues to review our processes so that they meet the modern challenges. Today, because we're so many, you can't just gossip about somebody and that becomes the yardstick by which you appoint the person to the judiciary. There has to be a more deliberate design on how these things are done.
One of the reforms that you've also talked about, budgeting and accounting. I know the popular one that gets talked about is, that famous memo that was leaked by some justices of the Supreme Court, talking about their welfare and the conditions under which they work and their salary structure and all of that, which everybody likes to talk about. But with regards to budget and accounting, what are the specifics of the reforms that your committee is proposing?
There are two levels. There's the pedestrian level, which what everybody talks about. There's been a review of the civil service pay and salaries 6 times since 2011. I think judges have only had their review twice. So clearly they're deprived, and the committee is looking to ensure that at the very least, they're at par with their contemporaries who are actually outside the judiciary. So that's the first point. But I think the more complicated issue is what I would say is how monies that are spent, how monies that are allocated to the judiciary is spent. And the recommendation is simple. The administration of justice must be distinguished from the administration of the court system. So, and I'm hoping that the recommendation, which makes a lot of sense, and this again based on how it is done in other jurisdictions, where you demarcate the administration of justice from the administration of the court system. That is important.
So tell us on live TV what criteria we can use to measure the performance of the committee, say after 12 months.
Some are not in our control, but I can tell you that as far as appointment, selection, and elevation of judges are concerned, there will be a firm recommendation to council. How far council takes that and how quickly it implements it is beyond my control. But we will, because I sit in that committee, so I can tell you, and we're working assiduously to put something in place.
Welcome back. We move on now to the just concluded 9th Lagos Economic Summit, tagged Betty 2022. It was held from the 11th to the 12th of October with the theme Lagos 2022 to 2052, charting the path to sustainable development, the 30-year plan. In line with the foregoing, the Lagos State Ministry of Justice, led by the Attorney General, organized a plenary session on the civil litigation conundrum, where panelists discussed extensively the Lagos State Administration of Civil Justice Bill.
Professor Dieter, I mean, you have experience spanning...
The Lagos State Administration of Civil Justice Bill 2022 has got lawyers and members of the legal community excitedly looking forward to key reforms the bill would make. The bill by the Lagos State Ministry of Justice is currently undergoing deliberations, and it seeks, amongst other things, to aid economic growth, increase the confidence of the public in the judiciary, and promote the prompt litigation of civil cases in the state. At one of the plenary sessions of the 9th Betty Summit, moderated by the Lagos State Attorney General and Commissioner for Justice, Senior Advocate of Nigeria, Moyosore Onigbanjo, a panel of senior legal practitioners took a critical look at the drafting technique of the proposed bill, as well as some of the provisions in need of adjustments.
I think the issue of stay of proceedings is actually something that, just as it has happened in administration of criminal justice, we should just take out entirely. In the sense that every single thing that you want to deal with, leave the high court and then deal with it in the appellate court.
If you follow the Odi and Alaga line of cases, which prescribe that original process must be served in person, and you are seeking consent from the prospective defendant, how does that work in implementation? So whilst it's a laudable provision and should remain, I think more attention needs to be paid to how it will work and the circumstances in which it will work.
You then ask yourself, how do the judges operate this principle of indemnity where they have absolutely no evidence and the rule tells you immediately that they can assess summarily? How are they able to perform that if they are to indemnify the other party?
There has to be a proper jurisprudence around costs. It shouldn't be just arbitrary. It shouldn't be the way the judge feels on a particular day. There has to be a standard. There has to be, and the rules are there. We don't need to reinvent the wheel. You have a taxation of costs. In an ideal world, we should have, if you've engaged a senior advocate just for appearing in court one day, this is the minimum that you'll be charged in costs. So it's not really down to the parties anymore. The court will say, well, you give me your cost assessment, and if the other side doesn't agree, then we send it for taxation, and you have a registrar who specializes in that.
In order to ensure that the confidence bestowed on the court is not eroded, the panelists also discussed some of the challenges facing litigation of civil cases in Lagos state courts.
Now, for me, I get worried, for example, if a judge is telling me that on a particular day is the birthday of the chief judge and I'm not going to sit. And so when you say that to the hearing of litigant, you send a signal that justice doesn't really matter.
How we can get judges to confine themselves to a certain time frame when adjourning cases for rulings. It's a little ridiculous when you have an adjournment for a ruling on a simple matter like seeking to withdraw a suit, and then you get a 6-week adjournment.
In his closing remarks, the Attorney General encouraged every legal practitioner to be proactive and give more suggestions to further perfect the bill in order to facilitate the smooth administration of justice in Lagos State.
We will have a bar bench forum specifically for this law and all the engagement that we can. So this bill is not, we don't want anybody to see it as an executive bill. It's a bill for all the stakeholders in civil administration of civil justice.
Moving on now, the drive to create an environment that promotes female inclusion and workplace equality saw the creation of Women in the Profession, WIP, an empowerment initiative of the New York Bar in the United States of America. This initiative has since ensured the promotion and advancement of women in the legal profession and all women under the law. With branches established in other parts of the world, WIP launched its Nigerian chapter at a hybrid ceremony held on Friday, the 7th of October. And we have some details of what transpired at that launch in this next report.
The inaugural hybrid ceremony of the Women in the Profession, WIP, which took place at Detail Solicitors Lagos office, had in attendance leading female partners of law firms in and outside Nigeria, female lawyers in other organizations, and female law students, with over 150 more participants joining online. According to the organizers of the launch, statistics show that while women enter the legal profession in equal numbers to men, a high level of attrition occurs mostly before or at the mid-level stage of the women's careers. Why is this so? This launch presents results from a survey aptly themed Why Women Leave Law. One of the speakers, Tomilayo Fadoju, presents the results.
92% or 91% rather of our respondents said that the lack of work-life balance was the number one reason, followed by, interestingly, marriage. So our respondents felt that a woman's duties when she gets married is one of the reasons why she might decide to leave law.
Discussions were expanded by a panel session of 3 women, Kofo Dosekun, Michelle Thompson, and Derin Adefulu, who are at the top cadre of the legal profession, with their conversations centered on how to have a thriving legal career.
No matter how hard you work, if your work is not seen, it's as though you're not working. And so I think that one needs to manage the right balance between working hard and being able to show your stakeholders, who are the ones who would determine, for example, your promotion, your appraisals, that you are working hard.
The host and chairman of the Steering Committee of Women in the Profession Nigerian Chapter, Dolakbo Kukoyi, who moderated the panel session, emphasized the need for more stakeholders to join in striving for gender inclusiveness and equality.
Even though this is WIP Nigeria, we want to work with law firms. We want to work with the men because we want to ensure that we all do this together.
Participants at the training session here speak about their key takeaways from the event.
It's interesting that women are rising up to take their rightful place in the legal profession in Nigeria, and this is, in my opinion, a very good initiative.
The Nigerian mentality is that women should, be a bit subservient and not be too out there, but now we see a lot of women coming out, and something like this brings more people, all the younger ladies. It gives them hope. It gives us something to look forward to.
And what I'm keen to see, and which basically speaks to the importance of a time like this, is the fact that this discussion needs to be had with not just women in the room, but with a lot of men.
The chairman, Steering Committee, Women in Profession, also speaks further on the end goal and the aim of Women in the Profession initiative.
We want a safe space where women can come and be themselves. We want to also be able to help them advance. We want to be able to we want to be a resource center, a place where they can come and get resources to make themselves better.
And just before we go, let's do a quick recap of some of the top legal stories we're tracking at the courts.
We begin with the report that a three-man panel of the Court of Appeal has discharged the leader of the Independent Peoples of Biafra, Nnamdi Kanu, on the grounds that the Federal High Court lacks the jurisdiction to try him in view of his abduction and extraditionary rendition to Nigeria in flagrant violation of OAU Convention and Protocol on Extradition. Hours after the court's decision, the Office of the Attorney General of the Federation and Minister of Justice has clarified that Kanu was only discharged and not acquitted, as the court's decision was only on a single issue that borders on rendition. The federal government says it will consider all available options open to it on the judgment on rendition while pursuing determination of pre-rendition issues. Meanwhile, the Supreme Court has fixed October the 21st for judgment in an appeal filed by the Delta State governorship candidate of the People's Democratic Party in the 2023 governorship election, Mr. David Edive. At the Federal High Court in Abuja, Justice Inyanga Ko has fixed January 19, 2023 for hearing in a suit instituted by the People's Democratic Party against President Muhammadu Buhari's challenging the move to tamper with the Electoral Act 2022. Another Federal High Court sitting in Yola, the Adamawa state capital, has nullified the All Progressives Congress governorship primaries which produced Senator Aishatu Binani as the party's flag bearer for the 2023 general elections. In an over 3-hour judgment delivered by Justice Abdulaziz Anka, the court declared that the judgment is based on substantial evidence on non-compliance with the party guidelines and the Constitution of the Federal Republic of Nigeria. And we round off with the report that the Economic and Financial Crimes Commission has filed a 4-count money laundering charge against a former Attorney General and Commissioner for Justice in Lagos State, Senior Advocate of Nigeria, Chukwu Shashere. The former Lagos State Attorney General is to be arraigned on October 18th before Justice Chukwu Jeku Aneke.
And that's our program for this week. Don't forget that you can find these episodes of the program and past episodes on our YouTube channel. I am Shola Shayele. Thank you for watching and see you next week.